Good afternoon, everybody, and welcome to the weekly press briefing of the Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. In the case of Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi, the trial panel on 1st July issued the scheduling order for the pronouncement of the verdict in this case. The hearing is scheduled to take place on 16th September at 10 in the morning. Pre-registration is required. The hearing can also be followed through the streaming function on the Specialist Chambers website in the 3 languages of the court: Albanian, Serbian, and English. Also on 1st July, the trial panel issued an order reminding Hashim Thaçi of the modified detention conditions that apply to him, as well as of all other rules and regulations concerning his detention. The panel also directed his counsel to remind Mr. Thaçi of his obligations in that regard. Based on regular reporting by the registrar, the panel came to the conclusion that Mr. Thaçi has displayed a repeated pattern of non-compliance with the modified detention conditions, as well as other relevant detention rules and regulations. Should Mr. Thaçi not comply, the panel will consider stricter measures to ensure compliance with its orders. On 24th June, the trial panel granted in part a joint request by the defense to reject the amendments the prosecution made to their final trial brief. The prosecution had filed a corrected version of its final trial brief, making 3 amendments in footnotes. Minor clerical corrections to filings are permissible in certain circumstances prior to the issuance of a decision on the relevant filing. The panel permitted 2 changes to the footnotes in the final trial brief and rejected 1 where the prosecution had added a reference, as it would constitute an additional exhibit and as such fall under further submissions which are outside the permissible scope. In the trial of Hashim Thaçi, Bashkim Smakai, Izni Kilay, Fadil Fazliu, and Hayreddin Kuchi on the alleged influencing of witnesses, the appeals chamber granted in part an appeal by the prosecution of the single trial judge's decision on the admission of expert evidence and directed the single trial judge to re-evaluate the admissibility of the relevant evidence in accordance with the appeals panel's decision. The prosecution had requested the admission of an expert report and testimony from an expert witness who specialized in a specific analysis. However, the single trial judge had denied admissibility of the report because the method was not universally recognized in academia, the witness was not willing to fully disclose his methodology, and the prosecution had not secured authorization under Rule 107 to keep this information confidential. The appeals chamber found that to decide on the admissibility of evidence, the single trial judge should have applied a lower threshold of review, namely whether it is prima facie reliable, meaning whether the witness can, on its face, be considered an expert in the subject matter. In the appeals chamber's view, absolute transparency on every step of the methodology employed is not necessary for the admission of evidence. Because the witness adequately explained his general parameters and internal quality controls, the appeals chamber found that this report was sufficiently transparent for purposes of admissibility. Once the expert is admitted as a witness, it will be for the single trial judge to decide what weight to give to this evidence. The appeals chamber found that Rule 107 did not strictly speaking apply because the sensitive information the witness refused to disclose was not shared with the prosecution prior to the testimony, and therefore the prosecution was not required to clear it ahead of time. Furthermore, because the defense could cross-examine the witness on this issue, the appeals chambers did not see any prejudice towards the defense. Therefore, the appeals chamber remanded the issue to the single trial judge with the instruction to reassess the admissibility of the expert witness based on the findings of the appeals chamber. Following the decision, the single trial judge on 1st July invited the parties to file any submissions on the issue by 6th July. He also vacated all previous deadlines concerning the submission of the parties' final trial briefs and any related deadlines. On 30th June, the single trial judge ordered the parties to reclassify certain transcript of witness testimony to public and produce public redacted versions of some other similar transcripts. Concerning the testimony of one of the expert witnesses, the single trial judge ordered the prosecution to get in contact with the employer of the witness to determine whether the testimony can be reclassified as public or if there are any concerns on information security or the privacy of the witness. On 29th June, the single trial judge's decision on Fadil Fazliou's urgent request for variation of condition of release became available in a public redacted version. On 25th March, Mr. Fazliou's defense had requested that Mr. Fazliou be permitted to leave Kosovo to visit someone who was terminally ill, so he could say goodbye in a meaningful way while the person was still able to do so. The single trial judge granted the request, considering that Mr. Fazliou's travel would not enhance the previously identified moderate risk that he may obstruct the progress of proceedings, considering that the same conditions of release apply during the travel. The single trial judge also based his decision on the person's medical records and the fact that the person is a close family member, reminding that serious medical conditions of close family members have in the past been a basis for provisional release. The single trial judge also considered that the requested visit would not disrupt the progress of the proceedings, nor would it negatively affect the rights of the other accused in this case to a trial without undue delay. The panel reminded Mr. Fazliou that all other conditions set out in the decision on release continued to apply and ordered him to return his passport to the registry immediately upon his return to Kosovo. In a second decision, originally issued on 19th June 2026, the single trial judge denied a request by the Fazliou defense to allow Mr. Fazliou to travel to Montenegro to attend an event. The judge found that no good cause had been established to justify a variation of the existing conditions on his release, and that no compelling humanitarian grounds or other significant change of circumstances had been shown. On 25th June, the specialist chambers of the Supreme Court dismissed in its entirety Pieter Schala's request for protection of legality concerning the reparations order against him. Among the four grounds raised, Mr. Schala submitted that the trial panel had committed a substantial violation of the procedures by conducting separate reparation proceedings before his convictions were considered final on appeal, and that the trial panel erred by holding him liable to repair harm that was not caused by his acts or omissions, but by the crimes in respect of which Mr. Schala was convicted. The Supreme Court panel rejected Mr. Schala's submissions in relation to the sequencing of the issuance of the reparations order. The Supreme Court panel further noted that the appeals panel had found that the trial panel correctly determined that reparations are to be awarded based on the harm suffered as a direct result of the commission of a crime within the jurisdiction of the specialist chambers in relation to which a person has already been convicted, and that Mr. Schala merely disagreed with the interpretation given by the trial and appeals panels without substantiating his arguments. The Supreme Court panel observed, with respect to the second ground raised by Mr. Schala, that the appeals panel determined that the standard of review for appellate proceedings also applies to appeals against reparation orders, and, having carefully considered Mr. Schalla's submissions, was not persuaded that the appeals panel erred in this respect. The Supreme Court panel concluded that Mr. Schalla failed to show a substantial violation of the procedures by the Trial and Appeals panel in relation to all 4 grounds and rejected his referral in its entirety. That was all from me for today. If there are any questions, I'll be happy to respond. I think there are no questions today. Thank you very much for joining. The next KSC Press Briefing will take place next week on Thursday at 2:30 in the afternoon. I wish you a nice rest of the day.